Madam Clerk, would you open the courtroom, please?
Yes, Your Honor. The State of Michigan 36th District Court is now in session with the Honorable David S. Robinson Jr. presiding. Good morning, Your Honor. Good morning, everyone.
Good morning. Mr. Rosen?
How are you?
Fine, yourself?
I've got to look real close on my phone because there are some courts, when I come on, they automatically got the lawyer on mute. And so I start putting my appearance on the record and the judge says, you know, the sign unmute.
I had Ms. King a minute ago.
Oh.
She turned off.
Yes, I'm here.
All right, let's get started. Turn your camera back, your video back on, please, ma'am. We are on the record. This is 22179-641, Credit Acceptance Corporation versus Megan King. Date and time for what appears to be our first pretrial on this matter. Your appearance.
Judge, may it please court, my name is Attorney Richard Bruson. My bar number is 35222, and I am the attorney of record for the plaintiff.
What is your name, ma'am? I'm sorry, repeat that, please.
Megan King.
Is it your intention to represent yourself in this matter?
Yes.
You have an absolute constitutional right to do that. What you do not have is to write your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer will bind you. Do you understand that?
Yes, I understand that. So
Okay.
I understand. Can I ask the question?
Ma'am, what is it? Ma'am, I did not hear you.
Or I have to pay for one?
Ma'am, I try that again. I only heard a couple words of that.
I said, in this, do I get a lawyer? Do I?
I think what you're asking, and again, I'm having trouble hearing you, is whether you get a court-appointed lawyer or whether you have to pay for a lawyer. Court-appointed lawyers are only involved in criminal cases. This is a civil case, not a criminal case. You have a right to hire an attorney if you want to, but the court will not appoint an attorney for you because this is a civil, not a criminal case. Do you understand that?
Yes, sir.
Okay, where are we on this file, people?
Judge, I can tell you that based on the register of actions, there is two defendants. We have Eddie Gennard Richardson and Megan King. Eddie Richardson has been defaulted with a default filed with the 36th District Court on June the 9th. I'm waiting for the 21-day period to expire on that before proceeding to entry of default judgment. With the answer raised by Megan King, I'm looking at that as a general answer of denial with affirmative defenses that I would ask for discovery, and I will send to Ms. King written documentation and discovery that will ask her to review, to verify the veracity of the complaint, and I will also make a production of document request inter alia, where she can produce any and all documents that will demonstrate a meritorious defense at the time of trial. So I ask for discovery. And that way, I think that will, a little discovery may go a long way here.
All right. Okay, then what I will do is I will open your written discovery. I will give you people a return date. Your return date with me will be August 23rd at 10 o'clock. Does that work for both of you?
Yes, Judge.
Ms. King, does that work for you?
Yes.
All right. The court is opening written discovery. Discovery is a method by which you may learn about the claims and defenses of the other side. Discovery includes such things as written interrogatories to be answered under oath, requests for production of documents, as well as requests for admissions. Mr. Rosen indicates he intends to do some written discovery. Ma'am, you have the absolute right to do the same written discovery if you want to. Again, any written discovery.
I don't know what that means, sir.
Written questions under oath that you can ask the other side, like they can ask you written questions under oath. Demands for production of documents, You can both send and receive those. Requests for admissions, you can send and receive those. So it's up to you if that's the course you want to do, if you want to proceed with that or do written discovery or not. That's something that you have to decide. So we'll see you guys again. I'm opening your written discovery, August 23rd, 10 o'clock. Thank you both for coming. Ma'am?
Ask you a question. Yes, because I'm not educated on this, but written something that I have to send in to the court, or I mean, what?
If you choose to send interrogatories, you must serve them on the other side. If you choose.
What are interrogatories?
Interrogatories, ma'am, are written questions to be answered under oath. If you choose to ask for production of documents, likewise, you must serve the other side, and in all those instances, serve proof of service with those documents. If you choose to serve requests for admissions.
How do I do that?
Ma'am, you generate the questions and the writings, and you serve the other side in mail. You have his address on the face of the complaint. You must serve him in writing. You must serve copies by first-class mail and serve proof of service along with those copies. If you want to do written interrogatories, questions under oath. If you want to do requests for productive documents, if you want to do requests for admissions, all of those things are now available to you, ma'am. We're going to send you out an order. And I'll talk to you again, August 23rd at 10 o'clock. Thank you for coming in. We are off the record.
Thank you, Judge.
That's some bullshit. I don't know what how the fuck I do this shit, man.
Hello?
Mr. Kirkos, good morning.
Morning, Judge. How are you today?
I'm great. How are you?
I'm good, thanks.
I'm waiting for your opponent to check in.
Oh,
Hello?
Hello?
Are you Kevin Hurst?
No,
What is your name?
Jimmy Gatlin.
Mr. Gatlin, you're not due here until 11 o'clock, sir.
Okay.
So you can either.
So what do I do?
Well, I can put you in the waiting room, or you can remove yourself and you can come back at 11 o'clock, whichever one you choose. Your case is.
we're gonna stay on, sir.
Okay.
We'll take the waiting room.
Okay, then what I'll do is I'll put you in the waiting room.
Okay,
Okay.
thank you.
Uh-huh.
Judge, can I ask you a question?
Ma'am?
Yes, hi. This is Miss Gatlin. We've never done this before, and I sent the paper back in stating that we got proof that we've been identity theft. And
Ma'am,
we've been trying to.
Excuse me. Let me start with something very basic here.
Okay.
Are you an attorney licensed to practice law in the state of Michigan?
No, sir.
Okay, ma'am, if you are not an attorney licensed to practice law in Michigan, you may not speak on behalf of a litigant where you are not a party to the litigation. The only
Okay,
party
Jimmy,
to the
tell him what you want.
litigation party is Mr. Jimmy Gatlin. You may not speak
Yes,
on his
sir.
behalf. So I'm gonna put you guys in the
Okay.
waiting room and we'll get to you at 11 o'clock or as soon as after as we can. Thank you.
Thank
Ms. Strickhart, I apparently do not have an appointment for you as of yet either. So I'll put you back in the waiting room.
Thank you, Judge. What time will you wait for him till?
10:30.
Okay, thank you, Judge.
Good. I get back to you soon.
Okay.
RCJFM with Symphony Number 2 by Etienne Nicolas Merleau, the French symphony composer in this work, alongside Beethoven, who was writing his symphonies. Meanwhile, composed works like that, he's made in France. He lived in the same years as Beethoven, 1763 to 17, the Rhenish Philharmonic Orchestra, Second Symphony. WRCJFM Detroit.
Support for WRCK is provided by Network USA. Come design and create your very own jewelry. Jewelry making classes with Elena Victoria promote self-confidence, encouragement, and more. Students will work on a different project each day. Morning and afternoon sessions are available the week of August 1st. Learn more at
Another Beethoven contemporary was Wolfgang Hummel, who was like Beethoven, but you also at the end, so that's the reason that he proposed. So we have remember.
We are on the record calling file number 21170-598, Midland Credit Management versus Kevin Hurst. By a notice dated June 28th, 2022. This matter set for hearing today at 10 o'clock on July 26th on the plaintiff's motion for summary disposition. It's now 10:30. The court has the plaintiff's motion for summary disposition. I have also received and reviewed the quote brief answer to plaintiff's motion for summary disposition filed on behalf of defendant. Could I have your appearance?
Yes, good morning, Your Honor. May it please the court, Suzanne Strickhartz, P 44018, on behalf of the plaintiff.
The defendant has failed to appear. Ms. Strickhartz, please proceed with your motion.
Yes, Your Honor, this is brought pursuant to MCR 2.116C10. We filed an action against an unpaid credit card account, principal damages in the amount of $1,196.73. The defendant filed an answer in which he conditionally accepted all of the allegations in the complaint, which we indicate in our brief. We believe that pursuant to MCR 2.111 C and F, that the allegations are deemed admitted. Be that as it may, the court did open up discovery. We exchanged documents. The defendant asked us to admit that that our client is the owner of the at-issue account, and we did admit that. So, Judge, as you know, pursuant to MCR 2.3 12D1, it is now conclusively admitted. And so in terms of any of the issues surrounding ownership of the account that the defendant raised in his brief answer to our motion, it is conclusively admitted at this time. As you know, Judge, your review of our documents, the credit card statements are going to the address at which the defendant is using on his pleading. There are purchases, there are payments, and the last statement of the account is the amount of the principal damage in this suit, as the defendant acknowledges in his response to our motion. So in light of the proofs, the discovery responses and results, the defendant's initial answer, we believe that there's no material issue of fact, and we would ask that you enter a judgment for the relief as prayed for in the complaint.
All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland Creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
Thank you, Judge. Have a wonderful day.
And you too, Mr. Gartz. We're off the record.
Okay, bye now.
By one Chong was the pianist with Beethoven's music. Johann Hummus, third pianist in Betty Wilson, JFL. Christopher Hogwood in the Academy of Ancient Music up next with Henry Purcell. G9 slow dance is called the Pavone. That's the music. So but in the mid-80s. 90.9 WRCJ FM and H2 in Detroit.
Listen.
the bottom of it say hello, that's me.
Oh,
Getting his attention early when he came up.
All right,
hello?
let's get started. We are on the record.
Okay,
This is 221888579 CKS Prime Investments versus Jimmy Gatlin. Date and time for what appears to be our first pretrial. Your appearances.
Good morning, Your Honor. Attorney Ashley Nonis, P77029 on behalf of plaintiff.
What is your name, sir?
my name is Jimmy Gatlin. I'm representing myself.
All right. This claim involves a collection. This is a collection matter. And looking at Mr. Gatlin's answer, he says he's not involved in this case. You sent him the fraud package?
Your Honor, we never received a copy of the answer, so I have no idea what it says or doesn't say.
All right, let me say one more thing, Mr. Gatlin, going forward. Anything you send to the court, you must serve the other side. You can't just send it to the court. You must serve both the court and the other side. You understand that?
Yes, Your Honor.
All right, what I'm going to do then is I'm going to give you a return date, and Ms. Nonis, we will include in your, along with your notice, a copy of the answer filed by the defendant.
Thank you.
Does August 23rd at 11 o'clock work for both of you?
Hold on.
That would be fine for me.
Okay, Mr. Gatlin?
When was that date? August what?
August 23rd at 11 o'clock. It's a Tuesday like today.
I have an eye appointment for eye surgery.
Then let's make it August 22nd, the day before, so we can get this done before your surgery. Does that work for everybody?
Okay. Okay.
That'd be fine.
All right, August 22nd at 11 o'clock. Your written discovery is now open, and Ms. Nonis will send you a copy of the answer filed on behalf of the defendant.
Great. Thank you, Your Honor.
All right, is there anything else we should accomplish today?
Not from plaintiff.
Mr. Gatlin?
Can she share with me what she has?
I can put you guys in the chat room. And I'll let you guys talk. And then when you're done, we'll talk to you again August 22nd at 11 o'clock. Put you in chat room. When you finish, you're free to leave.
Thank you.
All right, let's get you to chat room.
Thank you.